All right, this is Substantive Law by Antonia, Kailee, Chelynn, Tristen, Vincenzo, and Lily. So criminal prosecution versus civil action. Criminal prosecution is the action against those who commit a state or federal crime. Criminal prosecution is not cases of suing someone for damages or responsibility. There are two different sides. There's the moving party and the defending party. The moving party is the state, and the defending party is the person accused of the crime. Civil action is cases where one person is suing the other for property, tort, class action, or city complaints. Civil cases are usually for monetary damage and are person versus person, not the state. Instead of moving parties and states, there is a plaintiff and a defendant. The result of the civil action case is responsibility of damages that the defendant would have to pay rather than jail time. Common law versus civil law. Common law is decided by judicial systems rather than statutes. It emerged in the 14th century during the Middle Ages in England and had a large influence on American and British law. There must be no statutes that are relatable to the crime, and the judge shall settle the case. Statutory law, also known as civil law, has a system where there is detail on how a case is brought to court, how a claim is handled, procedure, and the scope of the punishment. It emerged in Europe around the 6th century and had large influence on medieval law. These cases will be civil action and not criminal offenses. These laws are passed by US Congress or the individual state's legislator. So what is a crime? Crime is defined by three different parts: the act, the mental state, and the causation between the act and the effect. First is the act, which is the act or omission that comprise the physical elements of a crime required by statute. Actus reus translates to guilty act, which is either voluntary or by omission, and omission is the failure to act when a crime is being committed and no effort was made to stop or intervene. For example, a parent who does not feed or care for their child is a failure to act, which results in a crime, which is child neglect. Second part is the mental state, the intent that is within the crime, and whether the offender purposefully committed the crime or not. And the Latin term mens rea translates to guilty mind. There has to be clear and convincing evidence that the defendant was in a guilty state of mind and knew what they were doing was wrong. The third part is causation, and it is the cause that holds the defendant liable with enough evidence, and it is a prerequisite for finding liability or a guilty verdict in both civil and criminal cases. So an example of this is leaving a gate open. A homeowner leaves the gate open, a child opens the gate, falls in the pool, and drowns, leaving the homeowner liable for the death of the child. Corpus delicti means no person can be convicted of a crime without evidence proving that the crime actually happened. Corpus delicti translates to the body of the crime, and this rule was put in place so that the government could not punish a person for a crime without evidence besides a confession. Mala in se. Mala in se is defined as an immoral act, whether it is legal by law or not. These acts are wrong within themselves, and examples of these are theft, rape, and murder, and there needs to be criminal intent behind these crimes. Three-strike offenses. Three-strike offenses is a law that refers to repeat offenders, typically for violent crimes, more specifically domestic violence. Three-strike laws mandate a life sentence after a third violation of a violent felony with no eligibility of parole. The goal is to reduce the number of violent crimes and allow deterrence to happen for these crimes. There's suspicion of the Eighth Amendment and three-strike laws, but three-strike laws are constitutional under the Eighth Amendment, even though there are long sentences for relatively minor offenses.
Malum prohibita. The definition is an act which is immoral because it is illegal, not because it is immoral. Mala prohibita are acts that are crimes not because they are evil, such as mala in se, but rather because some law prohibits the acts or omissions. They do not include mens rea because there's nothing inherently bad in these crimes. They don't necessitate a motive. Examples of malum prohibita would be gambling, prostitution, disorderly conduct, public intoxication, traffic violations, or drug possession. Mens rea. Criminal intent is referred to as mens rea. It's the guilty mind. It's a literal translation from Latin menitis rea. It's the plural form of mens rea. The legal requirement for a particular defendant to be found guilty of a specific offense is known as mens rea. In order to prove guilt in a criminal trial, it is typically required to establish the mens rea of the defendant. A defendant must have a guilty state of mind and be conscious of their misbehavior in order to be found guilty of the crime. They don't need to know that their actions are unlawful. Mental states typically categorize hierarchically depending on how blameworthy an offender is. When categorizing the Model Penal Code and mens rea, most states categorize distinct mental illnesses according to the MPC. The MPC classifies and organizes guilty mental states into 4 hierarchical groups: acting purposely, acting knowingly, acting recklessly, and acting negligently. So some people have expanded the MPC classifications to include strict liability as a 5th state of mind. So for the strict responsibility offenses, there's no requirement for an attitude of guilt. All of the questions about the mental state of the defendant must be answered with a straightforward assertion that they were guilty of the offense. And possession and statutory rape are 2 examples of the strict liability offense in criminal law. Defenses refers to a lawyer's strategy used to discredit the accuser or the prosecution in a criminal case, both during the trial and during pre-trial motions. Just like everyone else, criminal defendants have rights. These rights are in effect from the moment you are detained on suspicion of the crime until you show up for the court hearing. There are times when cops missteps and transgress on your constitutional rights. There are often 4 main criminal defense tactics used by criminal attorneys in criminal cases: innocence, constitutional violation, self-defense, insanity, and an extra one, diminished capacity. Innocence is when the opposite side lacks strong evidence to convict you of your claim to be, and it may be ineffective. Your constitutional violations, your lawyer can submit a constitutional violation if your defense thinks that your rights have been violated. And that is when they don't read you your Miranda rights, they coerce you into a confession, unlawful search and seizures, things like that. Self-defense is the use of force when necessary to defend oneself or family members from bodily harm during an aggressor's attack, assuming the defender has a good reason to believe that they are in danger. And this is used by a lot of people, and it's justified when, except using excessive force. So you can defend your family or yourself, you just can't continue after the person is no longer harming you. Insanity is the defense that defendants may rise during a criminal trial, and diminished capacity is the defense of diminished capacity can be used to disprove the element of criminal intent, which is admitting to a smaller crime, which also goes into the reason of insanity. They go hand in hand together. Some tests used to determine insanity are the Magnat's rule, the irresistible impulse test, and the New Hampshire or Durham test, which is also known as the product test. The test suggested by the American Law Institute Model Criminal Code are some of the tests for insanity used in different US jurisdictions. So for the irresistible impulse test, it's used to determine whether an accused committed the offense despite knowing the nature and seriousness of the crime and being aware that it was wrong. The Magnat rule must be demonstrated that the accused had a mental deficiency at the time of the conduct that prevented them from being aware of the illegal nature and quality of the act, and that even if they were aware its criminal nature, they did not see it as wrong. And according to the product rule, if the defendant's mental illness contributed to or was the cause of the crime, the conviction should be rendered not guilty by reason of insanity. Procedural versus substantive defense. The rights and obligations that apply to both individuals and organizations are established by substantive law, which encompasses all laws with both universal and particular applicability. In particular, in a court of law, procedural law defines the legal guidelines by which substantive law is developed, applied, and enforced. While substantive due process is a legal principle that enables courts to avoid government interference with basic rights, procedural due process refers to the methods used to try and convict persons accused of crimes. By mandating specific steps to be taken in both criminal and civil cases, the procedural defense process restricts state and federal power. The foundation of substantive due process is the idea that the Constitution shields the populace against unjustified government interference with their fundamental rights. You can claim that your procedural due process rights were violated if there's an issue with the methods utilized to obtain evidence or to gain a conviction. A substantive due process analysis needs to be carried out whenever the government enacts a legislation that violates someone's right to life, liberty, or property. Alibi. As a defense to a criminal prosecution, an alibi is a claim that the accused was somewhere else when the crime was committed. Establishing an alibi is providing proof that you were not there at the time or place the crime was committed and hence could not have done the crime. If one of the most effective and persuasive legal defenses you can make when you are accused of a crime. An alibi defense must include three components. The defense was not present at the time or place of the crime. The defendant had no reasonable opportunity to commit the crime, and the defendant could not have committed the crime by other means. If you're able to prove all three of these, your alibi defense has been successful. Unfounded offense. Unfounded offenses, this category is used when a police investigation demonstrates that the reported occurrence was false or without foundation and that had no offense actually happened or was intended. Unfounded refers to the alleged misbehavior as stated in a complaint or has brought to the commission's attention in another way. An example of unfounded means, given the information at hand, it's highly unlikely that any child abuse or neglect took place. If the alleged act didn't happen, it was unfounded. Finding refers to the commission's judgment following a review, investigation, or audit of a topic falling under its purview.
Entrapment. Entrapment is a defense used when government officials induce someone to commit a crime. The individual would not have otherwise committed the crime or crimes, so it makes it hard for that defense to go if they have a past criminal history and the officer conduct that goes beyond what is reasonable and crosses into the line of coercion. So the reasoning is that it's unethical to punish someone for a crime manufactured by the government. The defendant has the burden to establish and prove that the idea for the crime was improperly introduced by government officials. The defendant was not willing or predisposed to commit the crime, and the government agents persuaded or talked the person into committing the crime. Duress defense. This is another defense used. It's used when individuals committed a crime against their will because they were facing the imminent threat of death or the use of physical force. The reasoning is that they should be excused from criminal liability as there was no safe or realistic alternative to committing the crime, and any other reasonable person in the defendant's position would have also committed the crime. The elements needed to prove duress defense are reasonable fear of imminent death or serious bodily harm, fear established through the words or actions of another person, no reasonable opportunity to escape the threat or alternative to committing the crime, and it occurred through no fault of the defendant. Statute of limitations. This is the time limit on the period during which legal action can be taken for a particular type of offense. The statute of limitations exists for both civil and criminal cases. Typically, a longer time period does exist for felonies than it does for misdemeanors. When the statute of limitations ends, the legal claim is not valid and can no longer be prosecuted. Some exceptions do exist. For example, if the victim is under 18, the statute of limitations ensures that a fair and timely trial can be conducted. The evidence will still be fresh and all parties have accurate memories and can be found. The length for a specific type of crime depends on the jurisdiction and the offense itself. It'll vary state by state and federally, and for some crimes, there's no statute of limitations, one example being murder. Public duty defense. This is a doctrine that provides immunity to public employees for injuries that are resulted from a breach of duty of care owed to the general public instead of to that individual. This is assuming the officer is acting in good faith and within the scope of their authority. Public officials have a duty to protect the public and should not be held personally liable for injuries or damages that occur while fulfilling that duty. This exists because everyone would be suing police officers for what happened to them. And one phrase that goes along with it is duty to all, duty to no one, which means that the duty owed to the public as a whole is prioritized and must be distinguished from the duty owed to a particular individual. Self-defense. This is another defense that people can use, it allowing an individual to use physical force to prevent injury or death. The defendant must reasonably believe that they are in imminent danger of bodily harm. The use of force cannot be used to carry out an unlawful act or to respond to a situation that was created intentionally by the individual. Two principles that go along with self-defense are proportionality and the duty to retreat. Proportionality is the use of force in self-defense must be reasonable to the perceived threat, and the duty to retreat is the requirement to safely retreat from a dangerous situation before using force. Every state's self-defense laws are a little bit different. Pennsylvania falls under Castle Doctrine. This allows the use of reasonable force in self-defense in one's home with no duty to retreat. And an individual may use the level of force they believe is necessary, and this could include deadly force. White-collar crimes. These are nonviolent, financially motivated crimes committed by individuals, businesses, or government professionals. These could be entrapment or fraud. They exploit social, economic, or other powers for personal, corporate, and/or financial gain. White-collar criminals are seen as less blameworthy and risky than traditional criminals, and they receive more lenient sentences. White-collar crime is one of the fastest-growing crimes in the world. It uses complex schemes with sophisticated measures that go undetected for a long time. The term white-collar was coined in 1939 by Edwin Sutherland, an American criminologist. One principle that goes along with it is the responsible corporate officer doctrine. It's the presumption that a high-ranking employee is aware of and liable for the corporation's wrongdoing.
Okay, so law evolves through the legislative process. In the United States, this process can take many years and can be very complex. The first step of the process is the proposal. In this step, representatives get support from others to sponsor the bill, and it is then sent to the committee. The next two steps are the committee review and the committee voting. These steps are repeated 3 times over, once with the Senate, once with the House, and once with the joint Senate and House together. During these steps, committees review and vote on the bill. And if it makes it past all 3 readings, it moves on to the president, where he can sign the bill, veto it, or do nothing. If the president vetoes the bill, it goes back to the House and Senate to be reconsidered. If 2/3 of the Congress vote to pass the bill, the veto is overridden and the bill becomes law. The McNaughton rule is the legal standard for determining criminal insanity. In some jurisdictions, the McNaughton rule is based on the 1843 case of Daniel McNaughton in England. McNaughton was attempting to kill the prime minister, but when he instead killed the secretary, Edward Drummond. Under this test, defense lawyers must be able to prove one of the 2 elements. The first element being, did the defendant not know what they were doing when they committed said act? And the second element being, did the defendant know what they were doing, but did not know that it was wrong? So here are 2 examples of the McNaughton rule. The first example, the defendant cuts a woman's throat under the delusion that he is cutting a loaf of bread. This is covered under the first element because the defendant did not know what he was doing at the time of the act. And the second example is the defendant chops off a sleeping man's head because he has the deluded idea that it would be great fun to see the man looking for it when he wakes up. This is covered under the second element because the defendant knew what he was doing, but at the time did not know it was wrong. Sociology of law is a subfield of sociology that focuses on the social, political, and economic factors that shape the development and operation of law. It explores how law is created, how it is applied, and how it affects individuals and society as a whole. In short, sociology of law explores the relationship between law and social change. Some of the key thinkers in sociology of law include Karl Marx, who contributed to conflict theory, which states that society is in a continuous conflict through the competition for limited resources. The second, Emil Durkheim, he believes society exerted a powerful force on the people. And Edward Sutherland, who sought to understand how deviant behavior developed. And he believed that it developed throughout society and that it was learned. Philosophy of law is the study of nature of law and its relationship to other aspects of life and society. It is concerned with questions such as what is law, what is its purpose, and how should it be made and enforced, and what is its relationship to morality, justice, and political authority. Some of the popular questions that we see today in philosophy of law are closely tied to questions in ethics about when we should be held morally responsible and or morally blameworthy for our actions. Some of the key thinkers in philosophy of law include Thomas Hobbes, who contributed to social contract theory, which was the agreement to conform within society. Jeremy Bentham, who is the father of utilitarianism, which states that a law is good or bad depending on the happiness of a population. And John Locke, who was a big natural rights advocate, he believed all persons are owed equal rights and those rights must be protected. Criminal liability refers to the responsibility of a person to be punished for committing a crime. In other words, the blameworthiness of a criminal. In criminal law, criminal liability is established by the concurrence of two elements, actus reus and mens rea. Actus reus refers to the physical or external aspect of a crime, which involves the commission of a forbidden act or omission of a required act. Two examples of actus reus would be the taking of cash during a robbery. An example of omission would be running a stop sign. Mens rea refers to the mental element of a crime, which involves the intent to commit a crime, knowledge of the wrongfulness of the act, or recklessness. Two examples of the mens rea would be that the robber intended to rob a bank and knew it was wrong, and that the driver knew it was wrong to run the stop sign. For criminal liability requires that a person have both a guilty act and a guilty mind. And criminal negligence refers to a defendant who acts in disregard of serious risk of harm that a reasonable person in the same situation would have perceived. Some offenses that may result from criminal negligence include involuntary manslaughter, negligent vehicular manslaughter, criminal neglect or endangerment of a child. The most common one that we see today is a person who operates a motor vehicle while under the influence of drugs or alcohol. They could be charged with criminal negligence if they cause an accident that results in injury or death. Penalties for criminal negligence can vary depending on the jurisdiction, but may include imprisonment, fines, or both.
All right, duress is a very specific crime that occurs when one individual is threatening another with the intent to get that person to do something they wouldn't have done otherwise. This definition is expanded in the 2010 case of McCord versus Good, which says that the threat must be imminent and the party must have no present means of protection. So can occur in many ways. So there are many different types of duress. Duress in contract law this is where duress is most commonly seen and it's most commonly used as a defense is under contract law. This is when the plaintiff is claiming to have been forced into signing a contract that they wouldn't have otherwise signed. This type of duress can either be physical, meaning that they were physically threatened, or it can be economic as well, which means that their financial status is being used against them or that they're being threatened somehow with financial ruin. Duress in criminal law is when the defendant is forced into an action through direct harm or through the threat of harm. And a caveat with this, in this defense, there cannot be any other action besides committing the crime that would protect the person from the violence being either threatened or directly inflicted. Rape shield laws are laws that bar the use of certain evidence in a rape case in order to protect the victims of sex crimes and to make sure that their sexual history is not used against them. The first rape shield law was passed in Michigan in 1974, and ever since the 70s and 80s, we have been seeing more and more protections come into place. So what sort of evidence is not admissible in a sexual misconduct trial? In order to answer that question, we really have to look at the Federal Rule of Evidence 412, which is the law that it lines out all the federal requirements. So again, this bars evidence of past sexual behavior as well as evidence of possible sexual predisposition of the defendant. There are several exceptions to this rule. One of the exceptions is any specific instances of someone's sexual behavior that can prove that that individual was with someone other than the defendant who was the source of the DNA. So if they can claim that they had sex with somebody specifically who was instead the source of any DNA samples that were taken instead of the defendant, that would be admissible. Another exception would be any specific instances of sexual behavior that the victim had with the defendant in order to prove consent. And the last exception would be any evidence that is constitutionally necessary when, if withheld, would be constitutionally violate the constitutional rights of the defendant. So a felony is any crime more serious than a misdemeanor, and they are punishable by either death or imprisonment for longer than 1 year. Felonies can either be federal or state, and federal felonies are classified from a Class A felony all the way to a Class E felony, Class A being the most severe. Class A felonies have max sentences of life imprisonment or the death penalty. And this would be for something like bank robbery or terrorism, and they also come with a max fine of $250,000. The minimum sentence of a Class E felony would only be 1 year in prison, all the way up to 5 years in prison, and this would be for something like unlawful practicing of the law. For the other classes of felonies, some examples would be human trafficking would be classified as a Class B felony, endangering a child or involuntary manslaughter would be a Class C felony, and unlawful abortion or falsifying documents required for voting would be a Class D felony. For state felonies, each state has a different classification system, but Pennsylvania classifies them from F1 all the way to F3, again being F1 being the most severe. F1 felonies have the max sentence of 10 to 20 years in prison, and this would be for something like kidnapping. They also carry a maximum fine of $25,000. The minimum sentence of an F3 felony would be 3.5 to 7 years in prison, and this would be for something like possession of child pornography. And in the middle, F2 felony examples would be sexual assault or aggravated assault. Misdemeanors are crimes much less serious than a felony, but they're still more serious than a simple infraction. The federal requirement is that the maximum sentence cannot be any more than 364 days, so it has to be right under a year. And in Pennsylvania, they don't come with a maximum sentence of more than 5 years. Federal misdemeanors are classified from A to C, A being the most severe, C being the least severe. And again, the maximum sentence is no more than 1 year in prison, and so that would be for something like assaulting a federal officer, and minimum sentences are only 30 days. And this would be for something like intimidation of voters. And so for state misdemeanors, not all state misdemeanors are classified in Pennsylvania, but they go from 1st degree to 3rd degree. Maximum sentences are 5 years in prison for something like terroristic threats or stalking, and the minimum sentence would only be 90 days in jail for something as simple as possession of marijuana. Involuntary intoxication is a defense that is used. This is not a defense in every single state, but in the states where it is recognized, this would be used successfully when the defendant proves that they unknowingly ingested any sort of liquor or drugs or intoxicating substance by force or deception. And this evidence would also have to prove that the defendant should not be held liable for their actions because of their intoxicated state that they didn't consent to, which means that they would be unable to form the necessary intent while in this state. And most of the time, if this defense is used successfully, it doesn't completely exempt someone from guilt. It just reduces overall culpability a little bit.
A nonviolent act or nonviolent crime is when there is no injury or force used on a person. Nonviolent offenders on average only serve a third of their sentence. The punishments for nonviolent crimes are short prison times and fines. And 3/4 of all prisons are filled with nonviolent offenders. The felony murder rule states that anyone can be charged with murder if in the commission of a crime committed, can be charged with murder if a commission of committing a felony results in death. If, for example, if A and B rob a bank and A kills someone, both A and B could be charged with murder even though B did not kill anyone. Almost every state has this rule, and the death penalty can be used. Provocation is an act of provoking or instigating someone to do something. Provocation is not a complete defense, but it can lessen the damage and culpability. Provocation is a more of an emotional motivation to commit a crime. Examples of like adultery, assault, manslaughter, in which provocation can be involved, can allow the punishment to be more lenient. Provocation can only take place if a provoker promotes the person with intent to commit a crime against the provoked who had no intention of commit a crime. Law versus morality. What is legal and what is moral are often intertwined with each other, but they're most of the time different. A good example is when the law is broken, the consequences is state penalties, such as prison time or fines. But when something is someone is morally disapproved, the consequences more is guilt or public or social disapproval, and maybe even rejection. The law is all about sanctions and imprisonments to enforce public safety, while moral rules are more about based on a person's values or religion or the culture of that group. While the law can be taught, when the law can be taught through education, morality is more taught through personal values such as family or friends. Strict liability crimes is a degree in which when a defendant is liable for committing a crime regardless of the intent or the state of mind. This is both admissible in civil and criminal law. Strict liability is often associated with minor offenses in criminal law. In civil law, the defendant is held fully responsible for any injury regardless of the intent. There are a small number of defense methods to strict liability. Examples of negligence, assumption of risk, abuse, and fault.